All right, welcome to our Virtual Justice on the Block Legal Information Clinic. This clinic is part of the virtual series Barriers to Disaster Recovery. To help us learn more about rent-to-own contracts, we have Giovanni Bush, Disaster Response Attorney in the Tallahassee Office of Legal Services of North Florida, and Ryan Phillips, Disaster Response Attorney in the Panama City Office of Legal Services of North Florida. As always, this video provides legal information and should not be considered legal advice. This video does not create an attorney-client privilege or substitute legal advice you've been given. You may have defenses that we haven't discussed here, so seeking an attorney or legal help is always advisable. Take it away, guys.
Awesome. Thank you so much, Rachel.
All right. Thank you, Rachel. I guess I'll start. And Gio, I'm going to ask you just to start out by, can you tell us, when we're looking at disaster recovery and barriers to that, why would rental purchase agreements be an important topic to discuss?
Yeah, no, Ryan, thanks for reaching out. And by the way, I didn't know you're in our Panama City office. I guess Panama City Beach, but Panama City, Panama would be a lovely place to provide legal representation from as well. But no, barriers, right? So one of the things that Ryan and I, when we discussed hosting one of these clinics, we realized we have a lot of cases where we see rent-to-own contracts or faulty rental purchase agreements coming in the way from individuals who have been harmed by hurricane, specifically Hurricane Michael in our communities, not being able to make full claims for assistance from federal programs or state programs. A lot of times rent-to-own agreements can be kind of predatory in nature in the way that they're written. They can really target communities of individuals who otherwise wouldn't have had the opportunity to maybe receive financing for a home. But in doing so, they don't get the full protections of the law sometimes because of the way that these agreements are written too. And so what we see is that individuals have signed up for some of these rent-to-own agreements, and then they, in some instances, even paid them off, right? So they should now be owners of this property. And due to some technical reasons or faulty reasons, unbeknownst to them, they haven't gotten a deed. They don't have a title to this property. And that's a huge barrier. Because if you look to our previous clinic that we did about 2 weeks ago, you'll see we did a whole one regarding why it's important to have clear title to your home in order to receive benefits. And the long and short of it is individuals that have been affected by hurricanes or natural disasters, there's a timeline often set to programs that offer benefits to those that have been impacted. One example is FEMA. They actually have the ability to apply for any assistance for individuals that have been directly impacted by a hurricane. And one of those is individuals in the household program, it's called, set in place by FEMA. And while there's all these great ways to be able to apply, and you can look to our resources online on how to go through that process, it can be tough for individuals that have a rent-to-purchase agreement, have already paid it off, but they don't have a deed or title to their home. FEMA oftentimes will not allow those individuals to obtain certain types of home ownership benefits or repairs to the property without that clear title to the property, which can take a while. And so we thought it'd be good to go ahead and try to offer some protections or guidance now for individuals that might be either in a rent-to-purchase agreement or have completed one. As well as I know Ryan's probably going to share some thoughts about individuals that are maybe considering signing a rent-to-purchase agreement too, and just things to be wary about in the process. So,
all right, and we'll get into some of those issues with those predatory practices and some of the other things that can come up, including if the owner passes away, or the seller passes away before you've completed the contract, or even after you've completed the contract, but before you've gotten a deed from that person. But before we go into that, let me ask you, can you explain a little bit about the difference between a rental purchase agreement and an agreement for deed, or a contract for deed?
Oh, no, that's good. It's important to remember, right? So people have different language or terminology they might have for the type of contract they have for either the property that they own. The first one we hear about a lot, it's called a rental purchase agreement. And that's for a home, or it could be for a mobile home or manufactured home. And what you have is it's an actual agreement between a buyer and a seller that requires either all of the funds or part of the funds that a renter pays for in rent to be applied to the home for a final purchasing price, right? So under a rental purchase agreement, you see a seller has a home price that's set when the agreement is going to be finalized between the two parties. And so what happens here is you go from a traditional landlord renter tenant relationship, right? I'm just renting this, to actually being able to obtain some additional rights under the law, because you start to become essentially like you have a mortgage on the property, almost a co-owner. So renters under these agreements will have what they call an option, right? It's a key word, an option to be able to buy their homes. And that phrase, an option, sets a timeline for when they can actually choose to buy their home instead of just renting it out. It tends to be a specified amount, a specified determination of when they have that timeline for when they could make that choice to purchase the home. On the other hand, what we see sometimes are just kind of rent-to-own contracts that don't have a lot of the requirements of a rental purchase agreement under the law, right? And that a rent-to-own, they can almost be used synonymously sometimes when people use the phrase, but under the law, what we see, rent-to-own tends to be a lot more informal agreements, right? Where someone's renting a property and they say, if you want at any time, you can just elect to purchase the home, but you're not legally obligated to have to do so at any time. The other type of rent-to-own we see is not necessarily just for the home, but it's probably for the land itself. It's called an agreement for deed. An agreement for deed is often referred to as, we call it a land contract. And it simply is, it's an arrangement where a seller provides the owner with the financing to purchase a property, right? So there's almost, there tends to be monthly payments made by a buyer to the seller for this. And so a lot of times you'll see this being used similarly as a mortgage on the property itself. So the seller says, literally, once you make these monthly payments, you then get the land put back in your name. So during that time, if someone is in an agreement for deed, the person who's purchasing the land under this agreement for deed, they have the right to use and possess the properties under certain terms, but they don't have clear legal title until they've paid everything off and they get a deed. And so that's why they call it an agreement for deed, to get the deed. Yeah. Does that, I hope it helps clarify.
Yeah. Well, and therein lies some of the trouble, right? Because if there's a delay in getting the deed, things can happen between now and getting the deed, such as if the seller passes away. Yeah. And then dealing with, their heirs, and in hopes that they're going to, it depends on how well the contract is written, and we're going to get into that. That's true.
Well, I was going to say, even before you go to the deed portion, though, what we see a lot in landlord-tenant scenarios is people maybe who have signed these rental purchase agreements, right? And then a disaster hits. And then so what happens is they've got this agreement. It's not really a normal landlord-tenant thing. They have now paid to invest in this home. And now all of a sudden, after a hurricane comes, sometimes we see these terrible sellers or owners of the property tell the buyers, a lot of our clients, hey, you need to leave this property. You're getting evicted because a hurricane has occurred. Maybe there's damage to the property. And so, Ryan, what I wanted to ask you is kind of, what would you see? What are there any legal requirements or protections that could be put in place for any of the purchasers under a rental purchase agreement, right? Any of the tenants in the community, they've got one, a hurricane hits, they don't want to have to leave this property. They don't feel like they should. Are there protections for them under the law?
There are statutory protections under Florida's Landlord-Tenant Act, which is Section 83, covers the entire Landlord-Tenant Act. There's a particular section that states that a tenant cannot, with a valid rental purchase agreement, cannot be evicted under Florida's Landlord-Tenant Act. So there's an exclusion for folks with particular contracts. Now you have to meet certain parameters. You would have to at least have paid 12 months rent, or you've paid 1 month's rent and you've deposited at least 5% of the purchase price of the property. So if you've done this under Florida law, they treat you differently and you have more protection against a seller / landlord who decides maybe, well, I just want to go ahead and do an eviction because maybe there is damage to the property, and maybe there's all sorts of issues that could lead the landlord seller to want to move on to a different scenario and want to terminate the contract. And so this is what protects you. So long as you've been paying your installment payments correctly, then you can get that case thrown out of under the Florida Landlord Tenant Act.
Yeah, and I don't know how it's been in Panama City Beach, but I know here in Leon County, we've had the county court even say, listen, we don't even have the right to hear these cases, right? The word they use is jurisdiction. We can't even hear this case because if there's a valid rental purchase agreement and over 1 year of payment was made or a deposit that's over 5%, they say, listen, you're not just a normal tenant. You kind of own part of this property. You've entered into this agreement to own it. So we can't evict someone that owns part of the property themselves now, and they're on track to make those payments.
Yeah, it's presumed to be a debate about the title of real property. And at that point, the county court under eviction laws no longer has jurisdiction. And so they
can't even touch it.
Have to file it in circuit court. And yeah, that's an extra protection that you would have.
No, that's great. That's great. You mentioned, though, in order for someone to have that protection, they have to have a valid rental purchase agreement. And sometimes what we hear a lot is a concern where someone says, listen, I've signed a rental purchase agreement. I just am concerned. I don't know if it's valid or not. You know, is there any guidance about some things that should be within a rental purchase agreement, or any type of guidance you could provide them to say, yeah, this is valid, or it may not be valid if it's missing some things? What does the law require?
Well, the law requires that it be in writing first and foremost. And I'm sure that you've seen 1 or 2 clients come in and say, I have an oral contract to purchase this property, and I've paid 3-4 years, and it was a handshake agreement. That needs that seller may be willing to sign a written contract, and so that needs to be corrected. It's got to be in writing. It's got to be signed by both the lessor and the lessee, i.e. the seller and the buyer. And it would have to have all essential provisions completed. The Florida statute has some things on that. What must be in the contract. It can't be any blank spaces. There's got to be a notice to the buyer or the lessee that they shouldn't sign the contract if there's any blank spaces. I've seen contracts signed with blank spaces without witnesses. I would suggest that anyone who has one of these contracts signed, that they should have it signed in front of 2 witnesses and notarized. And but back to your question, you know, there's other provisions that must be included: the names of each party, the place of business of the lessor. That becomes important if there is an option. If there's an option, we've seen clients that that have come in and they believe they've made all their payments and they own the property, but you can see clearly buried in the last provision of the document, it says you have to exercise your option. And to exercise it, you've got to send formal certified mail notice that you can prove that you sent to the buyer, exercise or giving them notice that you are exercising your option, that you've paid all of the payments and that you expect them to convey a deed to you in return. And those are tricky
Ryan, if I could pause for what I'd call
Sure.
a best practice moment with Ryan Phillips. So when there is that option, right? Someone says, I am renting this, but I want to make clear that I'm under this contract I've signed, this rental purchase contract, I want my right to exercise this option to purchase. A Ryan Phillips best practice moment would say, hey, go ahead and get that option sent via a signed letter via certified mail.
Right. And it looks sort of vague, I'm sure, to a lot of people, the terminology in the contract. So you can always come to our office, ask for, submit an application. We can look at any contracts that you may be thinking about signing, or if there's a contract that has an option. I've had some of those come in, and a lot of these clients really weren't aware that they had to send that technical notice and that all their rights under the contract technically could be thrown out the window if they did not comply with that one provision. And we've helped folks draft those letters, and it's fairly simple. You follow the contract, you use the seller's address that's indicated in the contract, send it certified mail where you have proof that you've done it. And you essentially just say, I am exercising the option because I've paid the full amount, and you list out what you've paid. And unfortunately, a lot of people aren't aware of this. Mm-hmm. And that's why I would say contracts for deed are less risky for buyers. Because essentially there's still risk there. We could talk about those, but there's other things that you can do to include in the contract to protect yourself. And I guess if you want to ask me, Gio, I could go over some cases that I've seen, scenarios where the buyer did everything really that they thought they should have done, and they still lost the house that they thought that they were buying.
No, I think that'd be good. Let me ask you real quick. There is also a stupid proof provision for lawyers, right? Lawyers like to write these contracts oftentimes, and they could use a lot of lawyerese. Is there any requirement regarding the contract requiring it to be understandable under the law for individuals? Regarding the language that's used,
got to use clear writing and plain language. It needs to be divided by sections. There shouldn't be any ambiguity. When you read the contract, you should understand exactly what it means. And if there is any ambiguity, then you should renegotiate that provision.
That's right. That's good. So if you find yourself in a scenario, right, where the seller is trying to come at you in circuit court to say that you've lost your rights to the property, if you look at your rental purchase agreement and it's written in lawyerese language, right, Latin terms or things you have no idea what it means, that could be a defense you can raise, that they failed to adhere to the requirements under the law of including those key languages, clear, plain, and simple language. Because if not, then how can you have a contract where everyone agrees if you have no idea what's there? And so that's key. But Ryan, I wanted to ask you about, you have, as you mentioned, some predatory actions taken on by some sellers that you've seen in cases. And so if you could elaborate kind of some examples of just that inappropriate predatory actions by sellers that you've seen and ways that maybe individuals can protect themselves in some of those cases. I think it'd be helpful to kind of get a clear picture of what we're talking about.
I think one would be selling to a second buyer and then trying to evict the buyer, the first buyer, the client.
So you have a valid rental purchase agreement, and then there's another sale.
And you've made a down payment, and you've made your monthly payments. However, the seller never recorded the deed. This is something important, or recorded the contract. I'm sorry, not the deed, the contract. And this is something that I would suggest anybody who has a rent to own or a rental with an option a purchase option agreement, that they should record the document, and there actually should be, better yet, provisions in there that requires the seller to record it and doesn't allow the seller to put liens on the home. That's one other thing that can happen. If there's no provision in the contract that forbids the seller from doing that, they may say, well, it's not going to be paid off for 5 years. I'm just going to take out a loan for those 5 years on the property, and then it's encumbered. And then you end up in a really tough spot, because especially if you haven't recorded your contract. So the bank is going to come in and record their mortgage on what you think is your property.
Yeah. So imagine if you bought a car, and when you go to drive away with the car, you realize, wait a minute, the dealer actually took out a loan on that car. So there's a creditor coming at you saying, I actually own this car, you don't, and you lose it even though you've made all those payments. You could be there with hat in hand and unfortunately not get protection. So that requirement to record, I would call it the Ryan Phillips best practice tip number 2 of the day. The requirement to record. And why is recording important if you have someone else trying to come at it for a lien or a creditor coming to?
Recording matters so much, because that's the first thing that professionals do when they're looking at a property, whether it be giving a loan to a homeowner or buying the property. That's the other thing with these rent to own contracts and contracts for deeds. The buyer isn't as sophisticated as, say, the mortgage company, who might be working alongside the buyer if they could qualify for a mortgage, who would then have inspections, add a title search, all those things to ensure that the property doesn't have any liens on it, and that they will have free and clear title. And those things sort of get pushed to the side in these informal agreements, because typically the buyers do not have the funds to do that sort of due diligence. But I think that there are provisions that you can include in the contract that are fairly simple, if we get the word out, that would protect people a little bit more. One would be no liens on the property. And if you do put a lien on the property, then you can owe me damages as the buyer.
Yeah.
And have that in that contract.
Yeah, that's right. And damages meaning financial harm.
Correct.
Correct. Yeah. Right. I mean, you can owe
you
me
can
money
sue later. If they've put a lien on the property that you've purchased in violation of the contract, those types of things. And if you want to get a loan, let's say there's a disaster assistance type loan program, and you've paid for 20 years and you've paid up, you think you own that property, and then you find out 10 years later that there was never a deed conveyed, and that maybe the buyers passed away, and now you're dealing with their children to try to, or the probate court to try to. So there's those sorts of situations can be avoided if you have the right terms in the contract. And they're not that complicated. They're just unknown. Most of the contracts that you find online, the forms, they're sort of geared towards the homeowner and less geared towards the buyer and protecting them.
Yeah. No, you're right. You're right. I mean, that's a big thing too, as you said, being able to make sure that the agreement, first and foremost, that you sign, that rental purchase agreement, you understand everything there. It's got that key notice language that you brought up there, that it has to, there's actual specific language of the statutes from the laws of Florida quotes. And it says straightforward that the buyer cannot sign this rental purchase agreement before they read it, and it can't contain any of that blank spaces, and they are entitled to have an exact copy of that agreement too, to keep it to protect their legal rights. But once that's done, the next step is to make sure that some of those key language in there regarding protections to the buyer in there. So no liens to the property too. even as you mentioned, having the seller go ahead and record the agreement too, once that deposit's made, if possible. But if not, you can go down to Leon County Clerk of Court in our county, or your county court officials, to go and have them set that in the official records, right? And it's not too expensive. I believe in some counties it's around $35 a page or such too, depending on certain requirements, and then also the value of the specific property that you have. But that helps because we have in Florida right now a statewide program that was put in place to be able to help those who have been harmed by Hurricane Michael. And one of the issues that we had is individuals that had a rent-to-own agreement. And they may not have had a deed to the property, but they had that lease agreement saying, I actually have paid for this property, I own it. The program said, hey, that's fine. We actually will consider that agreement, that rental purchase agreement, as a valid home ownership, but it's got to be recorded.
Correct.
And so that was one of the key things to see in mind. So we have a lot of individuals that had yet to record that. And so being able to just make that simple investment to record that document helps out a lot. It also could stop individuals that might want to purchase that property, that they don't know that you have a rental purchase agreement. But if it's recorded, they might see it and say, ooh, red flag. We don't want to buy this property or approve this loan on this property if there's someone else paying to live there and paying to own that property. So it's
That's
a good
what
protection.
It was, even if we have folks out there who they may already have their contract, and some of these terms that we're emphasizing aren't in their contract, they could still protect themselves a little bit more by filing or recording the contract. And so that way, if Bank of America or maybe a new buyer, maybe they say, well, they haven't paid the contract yet, so I can still sell it. I can do another contract for deed with a new buyer, and charge a little extra because they're going to be owning the home. And so you've got some foul play coming from that, but you could protect yourself a little more or a lot by filing. And then that way, when that mortgage company goes and does their title search, they will see the contract, and it'll at least cause some issues, which is really
That's good.
Maybe all you have at that point.
That's good. That's good. Yeah. Now, beyond that too, Ryan, I wanted to touch base also. There are, besides required language in a rental purchase agreement, there are also what we call prohibited practices. And they're kind of odd. If you look at the law put in place, seems kind of like a hodgepodge of requirements, but they're just things that, the Florida legislature really wanted to make sure that people purchasing these properties through a rental purchase agreement, right? They're trying to buy a home, and they recognize that for a lot of individuals in the community, home prices are up. It could be hard to get financing right now. And so they have put these protections in place for individuals. But I just wanted to go over just a handful of them so people might know, hey, these are things that if they're in your rental purchase agreement, they should not be enforced, right? These parts should be considered invalid under the law because they're the Florida legislature said that they should not be ever enforced against you. So one of them is that if there's a garnishment of an individual's wages, right, for failing to pay a rental purchase agreement, the buyer can't come after the seller and say, hey, you know what, we're going to just take it straight from your paycheck or come after you for this. And so if there's a default and not paying the amount that's owed, then that's what it will be under the law. But they can't then immediately, as part of the rental purchase agreement, say we could take this straight from your wages too. Another one is, sometimes.
You mean the seller can't come after the buyer?
I apologize. Right? Yes. Seller cannot come after the buyer for the wages. Yeah, that's owned. The seller also can't try to then have the buyer sign a power of attorney where would grant then the right then for the seller to be able to act as the buyer in certain circumstances regarding the property too. And pretty much what has to happen is if there is any violation or default, then the seller has to go through a formal legal process in circuit court to get the property back too. And so what this provision is trying to do is to stop the seller from being able to just sign over your rights to me and I'll get everything settled away too. both with the titling of the property or any of the purchase agreements we had. Another one too is a seller just can't have in the rental purchase agreement the ability to unlawfully enter the property willy-nilly whenever they want, right? They actually have to go through a normal requirement, as you would in a normal landlord-tenant scenario, to say, hey, I'm going to give you fair notice if I need to come in there for any, even for emergency circumstances. It also can't allow an agent or anyone from the seller to say, hey, I'm coming in the property now, right? This is key after hurricane so that we see, because there could be damage to the property, but that doesn't give the right immediately for the seller to enter whenever they want, however they want. They still need to give some sort of notice or indication, that, hey, this is what I'm going to do. They also can't be a breach of the peace to get the property back, meaning a seller can't try to come in and say, I'm going to just take the property back. Or if it's a mobile home, go ahead and attach it. Or have it moved if you're not paying for this property. There has to be a formal legal process you go through. What I've seen often too is these agreements will have this language that says in there that if you sign this rental purchase agreement, you're going to waive any right to defend yourself in a court of law from any claims or defenses or anything. That can't be the case, because this is someone is buying this property, right? And they need to be able to retain their defenses under the law too. Another one is, sometimes you can see the requirement to have insurance on the property, but that requirement can't be for a seller to say, you know what, in this rental purchase agreement, you have to buy homeowners insurance or rental insurance from me directly. I'll get the policy out in my name because I own it. So it's to be homeowners insurance in my name. And then you're going to just pay me. That's not permitted. It would have to be renter's insurance first, and then that could transfer into a more of a formal homeowner's insurance or other forms of liability insurance once you receive the deed. Another one is a penalty for early termination, right? This is a key thing. You can't have the seller impose a penalty for early termination of a rental purchase agreement or for returning the rental property at any time, except there is the ability to, if for any reason a buyer is paying and then, unfortunately comes under hard times, especially during the pandemic, misses some payments, there is the possibility then for that buyer to reinstate the rental purchase agreement. And all that means is they're saying, I'm going to go ahead and let you know that I want to go ahead and recommit myself to this rental purchase agreement. And that language about reinstatement, right? Recommitting, what happens when I violate and I want to again redeem my right to the property? That needs to be in writing, the terms of which have to be clearly listed there in that rental purchase agreement. And the only fee really that a seller can try to retain from a buyer, the fees can only be listed to missed rental amounts or any fees related to that, and then a $5 reinstatement fee. It can't be astronomical. And so the Florida statute listed out very clearly what they are. And then
they're real quick, Gio, that astronomical fees that you mentioned, that's an effort to overwhelm the buyer and obtain possession of the property again by jacking up their total amount owed in a way that's not reasonable.
Exactly. Because if we can make it, you miss a couple of payments, and if we can make it so unreasonable with all these fees and fines that you could never pay it off, then the hope of the sellers, a lot of those predatory sellers, is that you're just going to move out and they'll put someone else in, and then you lose all the amounts that you've paid toward the property over time. And that's just a very harmful practice. So that's something important to know. Now, there are often requirements. If you look at the Florida law regarding reinstatements, meaning you've missed payments and now you've told, buyers missed payments and they told the seller, I want to reinstate my right to purchase this home again. It can include the requirement to have to give possession of the property over for a term or for specific requirements, because but it has to be clearly written there within that rental purchase agreement, what that means and what the amounts are, how many months of missed payments, what is the total amount that will be owed. A seller just can't say, okay, give me the home back now. There has to be a set terms within the rental purchase contract. And even still, if they really fully want to, a seller wants the property back, they have to go to circuit court and then try to get the property back through legal court proceedings. So that's key. The other one too I want to say is there can't be any fee for in-home collection of the rental payment. If it is, it has to be in writing and agreed to by both parties, and the amount of fees need to be listed there. But sometimes you'll see a seller come and say, listen, I'm going to come forward on the 3rd of each month and collect the amount that's owed. And I'm going to charge you $35 because I'm driving there myself. That can't be something that's created on the fly. That has to be in writing. It's part of the agreement, and the parties have to know and agree to it there too. So that's, those convenience charges, all of those little fees can add up, and we want to see you protected.
So that's something to know for tenants who see fees that they've never heard of before, that they simply can't just make these things up out of thin air. They have to be part of the contract.
Exactly. Especially, like, as we said, post-disaster, when things can be up in the air and you think, oh, I don't have access to a bank or ATM, or I don't know what to do. The landlord says, no worries, I'll come by and pick it up. But it's a $35 fee every time I do this. Those are those type of unexpected fees that, for you buyers out there, we don't want to see you shouldering those burdens of prohibited fees. But Ryan, I wanted to ask you then, beyond what these agreements can or can't do, what would you say if someone has a rental purchase agreement, made all the payments on time, they're doing fine there, but they still don't have a copy of a deed? What are some things that they can do? What does the law allow?
I would say first come to our office and we can take a look and see what needs to be done. It could be a variety of things. It could be you need to sue the seller to enforce the contract. And that's why when there is an option, a purchase option provision in the contract, I've been sure to make sure that my clients execute that option or exercise that option by sending a certified letter. And then that would give them the ability to sue the seller because they've done everything they're supposed to do under the contract. If they don't do that, and the seller technically under the contract law could say, no, he didn't exercise the option. The contract says this, he didn't do it. So it's my property still. And, those are things that we can help folks do. Obviously record your agreement if you can. If you're at that point where it's 20 years later and you're not sure where these people are, I would say come to us, because essentially you need to find the seller and get a deed, or either sue them or get a deed from their estate or sue them, depending on what happens. But those are, obviously a lot of sellers would say, oh, fine, I'll execute a deed. I didn't realize we had to do that. I forgot, or whatever. It's not necessarily going to be a situation where you have to fight the seller. They just may have not known themselves that they needed to execute the deed. The problem is when it's been 15, 20 years and you lose track of them, or maybe they've passed away, and it becomes a lot more complicated. Yeah. And in that area, I would say just, maybe submit an application with our office, or consult a private attorney.
Yeah, no, you're right too, Ryan, because what we see sometimes are for some properties could have multiple owners. And then because these are rent-to-own contracts, you often have a property manager in charge too. They might be in charge of the paperwork, right? And so these sellers sometimes might sell a property and then have a rent to purchase agreement, a valid one written up with the buyer, and then sell all the property. And then it goes to another place and another. And sometimes there's so many people in play. The question is, who has the original deed, or who has receipts of everything? But, if someone is saying, I've made the payments, but I've not received any confirmation from the seller, right, of what I owe, I don't even know what I owe under this. Does the law give any guidance there, or some clarity of what someone could do?
Yeah, there is a statute. Let's see, I'm trying to find some notes on this, Gio. Go ahead. I think you got it.
Yeah, well, no, there's one part too. So there is this one statute too that says pretty much it's not the buyer's sole responsibility to keep track of all the receipts, right? The seller has the burden under a rental purchase agreement to maintain an accounting, right? What does that mean? It
Right.
just means what are all the charges there? What are all the payments? And then there has to be in that document dates that connect the payments to the charges. And it has to be all connected to what is in that rental purchase agreement. And so a seller has to provide a copy upon a reasonable request. So if a buyer says, I don't know what I owe you anymore, even if it's a cash payment, the seller is required to keep a record of those cash payments. And that's key because if they can or they can't produce any information or documentation, that's a big burden that they violate. The second part of it is, okay, so that's an accounting of all that's owed. But the other one is if someone says, I paid everything off and I've never gotten documentation proving that, the law requires the seller, once all payments are made, to then go ahead and mail a letter demonstrating that the buyer is now the owner of that rental purchase unit, whether it be a manufactured home or a house. They have to say pretty much, I'm going to go ahead and convey you title eventually, but you are now the owner. And it's almost it's a document confirming that contract. So if you don't have it, you can come at them and say, hey, listen, I need you to help me out here. I've made all my payments. I want to go get a title. The reason why this is helpful is in some certain instances, it might be, especially for manufactured homes, you can't find the owner of the property, or the owner might be, it might have been sold to a new owner and a new owner as we sold. That original deed could be buried in paperwork somewhere. So if you need to go to the local court and the clerk of court and file a case and include for a manufactured home or mobile home, it's Florida's Department of Highway Safety and Motor Vehicles. You can file a suit saying I should get a title to this manufactured home, and I have proof of my agreement for deed, and I have even a letter from the owner there stating that I am, but the owner hasn't been able to receive the title. So could you please go ahead and convey me a deed? Can you give me a deed, DUV, for this property? It helps to have that letter and that requirement too.
Right. And that would change if the seller had passed away.
Exactly.
And you're in a more complicated scenario, right?
Yeah,
but
we
that's
see it all
the
the time. We do. And
people need to be aware that once they do pay that amount off, even though the seller is not insinuating that they still own the property, if that person dies and you do not have a deed from them yet, then you're going to be in a tight spot. So it's better to move as fast as you can and the deed is the most important. That's what conveys title. That's what you need. That's what you need to file in the public records.
Exactly.
That's the end zone. That's where you need to be.
Yeah.
I mean, I think we've covered a lot of good topics.
Yeah. Well, I just wanted to go over the violations, right? So
sure.
Sometimes what happens, if you've got a seller who says, you know what, sure, I'm not going to provide a receipt of the payments, tough luck, or I'm not going to give the deed. Maybe you're right. But who's to say? You said you've made all the payments, but I don't really have proof or receipts of all this. Is just what you're saying. In one instance, if you can produce the receipts to demonstrate you've made all the payments, that's good. But I know that can be tricky. But you can tell a seller, listen, I've made the payments. I know I have. You need to provide me a receipt of all the payments that I have made. Number one. But number two, if they don't, if you've got a tricky seller, right, that is playing fast and loose with this, it's important to know that there are some violations. And so, Ryan, do you know kind of what some of the violations might be, both criminal and or civil penalties?
Well, yeah, one that's important to note is that there is a criminal violation for a seller's willful violation of their obligation to provide an accounting or a receipt of the payments that the buyers made, and to comply with Florida's rental purchase agreement law, which would also include that once they've made all the payments, that they convey title to the buyer. Now, there are little, if it's an option contract, then you're in a it's not automatic. There's not an automatic provision under Florida law that requires the conveyance of the land if the seller or if the buyer never executes the option. And, but that aside, yes, there is a general provision that you've got to provide the title as soon as all the payments are made, and failure to comply with that could be a second-degree misdemeanor, which is punishable by up to 60 days in jail and a fine of $500. So there are provisions that protect against that, and that the buyer could use maybe in their second letter to the seller if the sellers refuse to convey the land, that emphasizes that there's also criminal charges if you do not comply with the law. And I've paid everything that I'm supposed to pay under the contract. I would mention folks should make sure that they're clear about taxes and who's responsible for the property taxes. Generally, it's going to be the buyer. Sometimes they will pay the seller, pay them back for the taxes that the seller paid. But I have seen cases where the seller has moved to evict based on the buyer didn't pay them back their taxes. Maybe they never said anything about this for 3, 4, 5 years, and then because maybe the taxes were only a couple $100 in some of these lower value properties, and they let it slide, and then they turn around and use that as an excuse to terminate the contract, and then you think that you've purchased this home, and they've found a slick way to terminate it. So that's another thing I would say to be aware of, and make sure that you either ensure that the contract says specifically how that's supposed to happen, whether you pay it directly as the buyer or you reimburse the seller on certain dates of the year. That stuff should be determined, to make sure that there's easy out for the seller if they decide they want to sell the home out from under you.
I mean, I think nothing's more upsetting to us as attorneys. We feel for our clients and those in the communities when they've been great tenants, great buyers. They've really done everything. And then because of some of those slippery provisions in there, right, that a couple $100 could try to erase all that hard work and all the funds that they put toward that investment property. And so we really want to not see that be the case, but, when we do see the opposite happening, where maybe someone's made all the correct payments and you see a seller that's really trying to be predatory in their nature, it is helpful to know that the law does allow civil penalties too that are quite extensive. They're a lot more than what we see under a normal landlord-tenant scenario, because, a buyer in these instances aren't a normal tenant. They're trying to own part of this property. And so the law gives them protection. So, that includes if there is an actual violation, what you could have is a tenant or a buyer can try to either seek money damages, they call it, damages in the court. It's for their financial harm. Could be either money damages or a set off of the amount that they would owe toward the land. It's either amount of the 25% for the total cost to acquire the home ownership, right? So if you say you're purchasing a mobile home that's $40,000, you'd be able to have $10,000 set off from the amount you would owe, or actual damages, meaning the amount that you've actually been harmed if it's over that amount, plus attorney's fees and costs sometimes for bringing the case too. And so it could be a huge amount of financial burden placed on any seller where you have complied as a buyer with every aspect and the seller's trying to get away with something. The law does not want to allow that to happen, but there's a catch. And the catch is you have to give notice. So you can't just say, look, you know all this, buyer. you have to give a formal legal notice, meaning certified mail is the best way to send it, but a certified letter demonstrating this is my notice, my requirement under the law that you have violated our agreement and the law, and you have failed to do so, and you have 30 days to remedy this. And if you've not corrected this within 30 days and alerted them specifically what they violated, then the court says, you know what, buyer, you might be entitled to some money damages, but you didn't give proper notice. So we'll go ahead and maybe give you the property back, but we're not going to set this off. We're not going to punish that seller for their bad behavior by making them cover 25% of what you would owe toward the property or the actual financial harm you had because you didn't give them notice. So in the same way that in normal landlord-tenant law, a seller or a landlord has to give notice to a tenant if they're going to do any sort of legal action. The same thing here applies, that you as a buyer, you as a tenant also have to give notice if you're going to try to continue on with some legal action. The law wants people to know and have what they call due process and some good protections to understand that, hey, there has been a penalty or a violation, and give a chance for people to cure that or fix that before immediately the courts start giving out money damages against people. So that's key. But if you have
we see a lot of clients in homeowner contractor cases that contractors walked off the job. The homeowner knows that the contractor knows he's walked off the job. They don't feel like they need to send any more than the text messages or emails that they've already sent that they believe is documented everything, but there's actually technically a rule that requires formal notice, just like this rule. And it's one of those deals where it's not hard to send or draft. It's just a matter of doing it and to protect yourself.
No, absolutely, absolutely. But it helps to know that these are the requirements. It's great to obtain just some legal guidance in the community, whether it's through legal services, where we can provide services to low-income individuals in the community too, or if you have a private attorney in town, it's helpful to know what your obligations are and how to protect yourself. So that way you don't find yourself in these situations after a hurricane disaster has occurred and you're burdened with trying to figure out then how to seek ownership of your property and how to go through this legal process. It's helpful at the outset from the very beginning to know what you're getting into. But we would recommend, if you have any questions about any of the things we've talked about, or you have a rental purchase agreement or an agreement for deed and you think, I don't have the deed for it, I don't know if it's valid, and you're entitled to our low or affordable legal services through our community or through your local community, go ahead and look us up online for legal services, legal services of North Florida, and lsnf.org, and you can be able to apply for assistance. And we'd love to be able to help anyone out there in the community we can be able to understand what's going on in these scenarios too. We're there for the community at writ large. So, yeah. Ryan, do you have any other thing too you wanted to be able to share or disclose?
I don't think, well, I guess maybe just final suggestions on provisions that just to sum up, things that you can talk about with the buyer and say, I just want to make sure I have this provision in the contract. One would be that you cannot obtain any loans or any liens on the property or loans. You can't mortgage the property. We will both, or others, say the seller is required to record the contract so that if any mortgage company or buyer comes along, they can see that, and that will create a hurdle. And let's see what else. You could do that. If the seller didn't do it, you could record it yourself, just to try to protect yourself as much as you can. Anything else that you can, those are top three that I know that.
Yeah, and make sure you have a copy of the rental purchase agreement. You're entitled to have one, and it should say in the rental purchase agreement that you are entitled to have one. And so if you don't have a copy, or maybe your landlord told you at one time, or the seller told you, oh, it's there, don't worry about it. Just make sure that you know what you've signed and agreed to, and to make sure that it's valid, so that way you can protect yourself. and have a copy in a safe, dry location, a place that you can keep it sealed and protected in the event of a hurricane disaster with your important legal documents. And then if you get it recorded, like Ryan said, then it's nice because it's always there as well. You can go and obtain a copy either online or from your county officials to be able to get a copy of those official records. It'll always be there. So that helps. And
you can always search the official records to see if there's any liens already on the property that you're looking to purchase. It doesn't require a login. You just you go to the website and you search by the property address, and you can see liens on the property.
Yeah, that's
At least
right.
in county official records, I'm sure it's the same everywhere, but
yeah, most of our counties have the opportunity to search online what the records are too. And if not too, there's also the ability to call into your county officials too for the records to determine if there might be anything, and they can offer assistance too. Now, generally, I want to remind all you viewers out there too, just like Rachel said, this has been general legal information and education as part of our educational series. But for more hands-on advice to a specific case, we recommend you consult legal counsel out there and available to you in your community as well too, to know that there might be additional defenses or information that are specific to your case in the claim brought that you desire to bring in. So because of that, we highly recommend if you have any legal questions, to go ahead and consult with legal counsel that's available to you. If this has been helpful or if you have more information that you want to know about disaster preparedness and protections, you can look online at lsnf.org. We've got a lot more webinars and resources available to you in the community. And so we'd love to be of help to you, and we appreciate the opportunity to share today.
All right. Thanks, Gio.
All right, Ryan. Thank you so much for your time. You all have a great one.
All right. You too.
Thank you.